Hello, this is Matt on the Moon Lambeau channel. A class action lawsuit has been filed specifically against former SEC Chairman Jay Clayton and former SEC Director of Corporate Finance William HINMAN. This is what so many in the XRP community have been calling for the longest time, as investigation within the XRP community on this has unfolded for over a year at this point, and we've full of all sorts of appearances of impropriety. And it looks probable that in some instances, between the two of them, laws may have actually been broken. And so I'll let lawyers actually figure that out. I'm not going to go so far as to make a claim, but I'm on the edge of it because it doesn't look right, and it just doesn't pass the smell test. And so a couple days ago, we just found this out today, but a couple days ago, this lawsuit was filed on behalf of a specific XRP holder and all similarly situated individuals. So, and you'll see what that means as I go through the specifics of this. But basically, anybody that bought XRP from the beginning of time up until the lawsuit occurred, and they note that the lawyer who is a member of the XRP community, his name is Fred Rispoli. I've actually highlighted some of his comments on the channel in the past having to do with legal matters with the SEC versus Ripple case. He noted that there are actually $42 billion in damages. That's what he pointed out, $42 billion in damages, and I'll be talking about that. He's also demanding that there be a jury trial, and we'll get through the specifics claimed here, but this document was 25 pages, and so it took me about an hour to read the whole thing while along the way highlighting the parts that I found most interesting to share with you listening to this and making some notes for myself. And so I've read the whole thing, and I'll be getting through that. Now, before getting through the specifics of this legal filing here, this lawsuit, I'm going to share with you the comments directly from Fred Rispoli, the attorney who filed this. He put out a thread earlier this morning. I think the right way to kick this off so you know where he's coming from, and I think you're all going to be rooting for the concept behind this. I'm going to start there, and then I'm going to jump into the specifics so you can hear this. Got some dead trees up in my hand again. You know I do. And I'll tell you this, before we even get to the specifics, I will tell you that he did a great job laying out the specific facts and circumstances that so many of us has been highlighting for over a year. It's fantastic. I'll also be putting out a separate video after this. My very next video will be on what attorney John Deaton had to say about this. I saw that John Deaton, he tagged me and a number of others in a thread on Twitter. I only had a chance to skim it because I already mapped this out and planned it out, and this is enough for one video, I assure you of that. This one might be a long video. I'll get through as quickly as I can. But after this, I'm going to go through attorney John Deaton's comments. It looked to me upon just skimming it that he did have some concerns and some critiques about what's going on with this lawsuit. And also I saw that Fred Rispoli did respond, and so I'm going to read through that. I haven't read his additional response either, but if I put it all in one video, my gosh, you're looking at probably over an hour. So I'm going to try, we're probably close to it anyway. I'm going to try to not make it go that long. But to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Okay, so again, let's start right now with what lawyer Fred Rispoli had to say in announcing that he had filed this lawsuit and sharing the document. XRP Army, I promise you're going to want to read this until the end. Those within the ranks are intimately aware of the corruption within a government entity that used to be founded on principles of justice and protection of individual rights. We also know, only now, that so many insiders knew of the corruption, the graft, and the scheming that has created an all-out assault on American and global innovation in digital assets and blockchain technology. This innovation improves and saves lives, frees people from debt slavery, and allows others to send real value to those in dire need, in poor, less fortunate, and unfairly neglected parts of the world. Alas, like nearly everything in life, innovation can save so many at such a large scale and at such reduced costs from the legacy system, well, that threatens long-entrenched, powerful interests. And those interests maintain their grip by persuading others to bend their will. We now know only some of the seedy underbelly of what happened behind closed doors, in secret, with Mr. Clayton hashtag Homer J. Clayton. We'll get to that in a minute here. And Mr. Hinman, hashtag Willie Hinman, regarding their conspiracy to destroy the XRP Ledger network. These two knew each and every XRP Ledger network user had a substantial interest in the growth and development of the XRP Ledger network. These two knew, while collecting taxpayer-funded government salaries, that the XRP Ledger network was a massive threat to the financial interests of their former clients and previous employers. Though many have rightly called for an investigation into this conduct, no investigation is coming. No congressional subpoenas are on the horizon. And besides a handful of lone voices, no other crypto communities are coming to stand by as allies in support of a just cause. In truth, the XRP army always knew this. It always was, and likely always will be, for the XRP army to shoulder. I promise I know how to talk, folks. I swear this is not the first day I've ever read anything. It always was, and likely always will be, for the XRP army to shoulder the burden alone. Nailed it. Carrying on its back the communities who are too blind to see they are only in the second row of the firing squad. But this thread is all about hope. Many of you still have no idea how important and how powerful you truly are. All it takes is one, which becomes two, then four, then eventually victory. On April 11th, 2022, a class action lawsuit was filed against CLAYTON and HINMAN for tortious interference in all XRP Ledger network users' valid business expectancy in the XRP Ledger network. The lead plaintiff and my client, Shannon O'Leary, decided to take a stand against what those two did to unintentionally harm hundreds of thousands of people, not just in the United States, but around the world. I am serving as Shannon's lawyer in my own personal capacity and with no affiliation but my own. This is a case I believe in. It is a case that is fundamentally about justice, fairness, and the rule of law. Mr. Clayton and Mr. Hinman, through their actions described in the complaint, LinkedIn final tweet, and operating outside of the SEC, took unreasonable and improper action to help their former and now current clients target a rival competitor blockchain network in order to destroy it. It didn't have to be like this. The XRP Ledger network, like all blockchain networks, should have been given a level playing field. The XRP army didn't ask for this fight. It didn't start this fight, but it will win this fight. And here is where the most important question comes into play. What will you do? Will you stand with Shannon? We can give a golf clap for that. I think we're all going to agree with that general sentiment, aren't we? That's a no-brainer. The SEC is full of asshats. There's been tremendous injustice done, harmed people that could not, in many cases, really, they're like the last person, if you're a good person, that you'd want to target or cause financial harm to. So many people. In some cases, life savings lost as a result of what happened with the SEC going after Ripple, causing panic selling, so on and so forth. The levels of hypocrisy, all of this, everything that we've been talking about for over a year now, we're all on board with the concept. Now, let's go ahead and jump into this. And as far as the question of what the impact of this is going to ultimately be, since I don't have a legal background, I don't have a firm answer for that, but I'm going to get all sorts of opinions for future videos, and we will be speaking about what potentially the impact of this could be. And so again, here it is now on your screen. I'll try and remember to scroll down for those of you looking at the screen as I go through this. And throughout this, you'll see that that attorney Rispoli references tortious. He makes there's tortious claims, and I'm sure many of you are aware of this, but just in case anybody doesn't know what the word tort means, it's a civil wrong that causes a claimant losses. That's it. So when you see tort, that's what's being referenced here. So let's start into this here, and this is actually right off the bat pretty funny. Check this out. Plaintiff Shannon O'Leary, individually and on behalf of all others similarly situated, allege the following against defendants Walter Joseph Homer J. Clayton III, hereinafter referred to as Homer J. Clayton or Homer, and William Hinman, hereinafter referred to as Willie Hinman or Willie. Based on personal knowledge, the investigation of counsel, and information and belief. A plaintiff believes substantial evidentiary support will exist for and further support the allegations set forth herein after a reasonable opportunity for discovery. So what probably caught your attention as I read through that was the name Homer and the name Willie. So upon reading that, I started laughing because that's like the first thing that I read out of this damn thing before I got any feedback from anybody else. I just saw that it was out there. I was like, oh, what is this? And so I downloaded the document and I just read that and I just started laughing. I was like, what is going on here? As I started reading it, I was like, I seriously, I paused and I had the same response that a lot of you out there had if you actually read this thing. I was like, wait a minute. Is this actually just a joke? It's definitely not April 1st, but I thought calling him Homer in a class action lawsuit, calling J. Clayton Homer and Bill Hinman Willie. And so I had to go back, and before reading any further, I was like, okay, before I read more of this, I want to make sure that this is actually a real thing here. And I was conflicted because I already was aware of Fred Rispoli, and I was like, well, I've already shared some stuff since I know he's an attorney. He has some thoughtful stuff to say, and I'd shared some of his comments on my channel. I was like, what's actually going on here? And I went to Twitter, and I found out that a lot of other people had the same response as me. He's like, is this a joke, though? Not everybody did, but that's well, not everybody necessarily read the document either. But upon reading it, and in fact, here's a tweet from my fellow XRP YouTuber, the Digital Asset Investor. He simply wrote, "Is the lawsuit a joke?" And he highlighted this screen grab, which is now full screen. And you know what that's from? It's from Fred Rispoli's website, which is now on your screen. This is the actual website, fredrispoli.com, and it simply reads as follows with a white background. Shannon and I, so that's the plaintiff, Shannon and I were so eager to sue Homer and Willie that the website is not even up yet. So I'll just note, that's not necessarily what you'd expect to see from something like this, so I was caught off guard. But Fred actually responded. It's on your screen if you want to read it. He basically said, no, it's just basically a placeholder, temporary fix, but this is 100% not a joke. It is a real thing. And upon reading the whole document, I can tell you, it's definitely no joke. And he knocked a lot of this stuff out of the park, to be perfectly frank with you, which is why a lot of the stuff in this document I'm not even going to cover, because it's just the stuff that if you've been paying attention, you know about from over a year of following this. All the stuff having to do with the improprieties, and you know it. I don't need to even go through it with you guys, I assume, at this point. But I did see, before recording this video, I cited that there was a John Deaton thread I just skinned over, and a thread from Fred Rispoli in response to that, or I think it was in response to it after that. And I did note, I didn't read, again, just having skimmed both very briefly, I did see that Fred got some, after getting responses from the XRP community, he did note that he's going to go ahead and amend this document and remove the name Willie and the name Homer, because it does take away from the seriousness of this. Like, oh, to be honest, I'm not at all trying to be rude. Like, I appreciate any sort of effort and good faith here for sure. But I was thinking, okay, what is the judge going to freaking think of this when he sees that there's this 25-page class action lawsuit and the defendants are Willie and Homer? Okay, so I was just kind of laughing. Like, and so mind you, on my channel, yes, I'll call William Hinman, I'll call him Billy Boy Hinman, whatever, and I'll call J. Clayton an asshat, but I'm just a commentator on YouTube. I'm not filing a legal document. Like, this is how I talk on this channel, is how I'd speak with you if you and I were sitting on a patio drinking a beer talking about this stuff. If I were going to file a lawsuit, though, I'd probably keep that stuff out. but anyway, he looks like he heard from the XRP community. It does seem that he's going to be changing that. So no harm, no foul, as far as I can tell. It looks like it's all fine. Just thought I'd mention it because I know you guys had been wondering about that. And then I want to cover just this part of the introduction right here. Back to this is the actual lawsuit again. This action stems from the unprecedented actions of two rogue United States Securities and Exchange Commission employees, defendants Homer and Willie, acting completely outside the course and scope of their employment at the SEC. Homer and Willie aided and abetted each other in a conspiracy to tortiously interfere with plaintiffs' valid business expectancy in the XRP ledger, hereinafter referred to as XRPL, networked by manipulating the SEC into investigating and later filing a federal lawsuit against plaintiff and all similarly situated XRPL network users, while simultaneously manipulating the SEC into not investigating the Ethereum network, the latter being a network substantially similar to the XRP Ledger network, but with the primary difference being that Homer and Willie's past and now current clients had a multi-billion-dollar stake at the Ethereum network. Homer and Willie were also hired directly as employees by companies with billion-dollar Ethereum network investments after each left the SEC, and were also the same companies Homer and Willie acted to benefit while at the SEC. Oh, yeah. Good old Homer and Willie, folks. It is funny, though. Like, for real, that's seriously funny. I've laughed quite a bit over it before recording this. So a little bit of it's worn off, but I still get a couple chuckles here and there as I'm reading through it. I'm like, I'm smiling. You can't see me, but I'm smiling as I'm reading Homer and Willie. Here we go. All right, now we're on to page 3 here. I wanted to highlight portion 5 here. So check this out. This gets to, like, the damages of this. Check this out. Ultimately, Homer and Willie's conduct... You got me. All right, folks. Come on, this is a good time here. Ultimately, Homer and Willie's conduct, wholly independent of the course and scope of their employment at the SEC, substantially impaired the business expectancy plaintiff had in the XRPL network, causing damages of at least $42 billion to the proposed class, though likely in excess of that number. This was done intentionally by Homer and Willie to unlawfully target plaintiff to plaintiff's detriment and the benefit of Homer and Willie's former and now current clients and employers. Homer and Willie's benefactors handsomely rewarded them for their exploits immediately upon each leaving the SEC. So there's that $42 billion charge. It's actually cited a little bit later on, so I'm going to come back to that. I do have some things to say about that because you're probably like, where'd that $42 billion come from? Yeah, well, we'll get to it. Let me go a little bit further now. I think I have to go through a number of pages because most of the next X number of pages, it was very well done. And so, like, as much as I'd love to highlight it all because I really appreciate all these facts being laid out so succinctly, it's not really the purpose of this particular video. I've covered this type of material before. So let me jump down now to page 10, and we'll pick up at point number 3, which is right here. There we go, towards the bottom of this page. Point number 3. Homer and Willie conspire to commit tortious interference. On December 13th, 2017, Willie directs the setup of a meeting with Lubin, Consensus, and lawyers from Homer's law firm, Sullivan Cromwell, to discuss how the SEC can provide regulatory cover to the Ethereum network given its genesis via ICO, initial coin offering, which Homer had already publicly stated was a categorical sale of unregistered securities. These efforts by Homer and Willie were a direct violation of each's categorical prohibition to engage in business with his former and now current clients. Yeah, so then those are the concerns that we've been talking about here for sure. And it is just bizarre to note that ICOs, Jay Clayton said everyone that he'd seen is every coin out there, you know, all these ICOs, all of them were securities. He publicly stated that. And then we know that Jay Clayton actually provided feedback on the Billy Boy Hinman Ethereum free pass speech. He provided feedback on that. He didn't say, whoa, hey, Billy Boy Hinman, are you sure you want to do this? Because every single coin launch I've seen, every ICO, it is a security from my perspective. Did he say that to Billy Boy Hinman? No, he didn't. I don't know what he told him, but he gave feedback, and then the speech went out as it went out. And Jay Clayton has seemed perfectly happy about that ever since, and he's publicly talked about it after that, talking about how it provided guidance for the market. There's video of him doing that, right? It's just freaking crazy stuff. Then you go down to page 11 here, and I highlighted point number 48 here. Here we go. On March 28th, 2018, Ethereum network investors meet secretly with Willie in his personal capacity outside of official SEC business, seeking to influence Willie to announce a regulatory free pass for the Ethereum network in which his former clients had a large investment, even though no official at the agency has sanctioned such conduct. And I wanted to mention this because this is true. This has been brought up by Attorney John Deaton and many others, myself included. And it's not actually part of the SEC versus Ripple case. I don't know how many people realize that. I've said it many times on this channel, but it's actually not part of the SEC case. The SEC versus Ripple case specifically is about whether or not XRP is or is not a security, or whether or not Ripple's sale of XRP represents an investment contract. And yes, Ripple, thankfully, they're going to be allowed to argue their fair notice defense, and that's good, so they can bring up all of these points. But in terms of the free pass and things that there are certain aspects that we've uncovered in XRP community's research, it's actually separate from this, and Attorney John Deaton has spoken about that. As much as we'd love that all to be considered, it's not. So it is kind of nice to see that this is being brought up quite forthrightly in this particular suit. Next, let's go down to page 13. Oh, here we go, towards the bottom, number 66 here. All right. Willie was provided a copy of the XRP Not a Security memo prior to giving his orchestrated speech to protect the Ethereum network and provide it with a regulatory free pass. Willie knew that, despite SEC staff concluding that XRP and Ether would have to fall into the same regulatory bucket given that XRP was more decentralized on every metric evaluated by the SEC as compared to Ether, providing the free pass to XRP as well would significantly harm his former and now current clients and substantially impair the lucrative employment opportunities available to him once he left the SEC. Well, here's the thing, and I'm just offering open, honest feedback on this. That's not quite right. There is no evidence that the SEC concluded in that memo that that XRP is not a security, and so there's no evidence that they concluded that Ethereum and XRP are in, like, quote, the same bucket, end quote. Now they may have, well, if they came to that conclusion, we don't have that information because that memo that's being said, that's never been released. And if there's additional documentation that would prove that, and there may be, I'm not denying that. I've speculated on that quite a bit. I'm just saying that it's not quite accurate to state that they did come to that conclusion, because here's what the conclusion they came to. All we know is that they didn't decide that XRP is a security, which is different than them saying it's not a security, because they can easily argue that we had an ongoing decision-making process, this or that, which makes it different. Now, also, I do acknowledge, though, that if that were to come out, that would still be damning for them, because that would play into Ripple's fair notice defense. But it is like those, but still, even so, I'm just being precise here. Those are two different concepts. The idea that XRP, they didn't come to the conclusion that XRP is a security, that we do know. That is different than claiming that they came to the conclusion that XRP is not a security. Those are two different things, so I'm just providing a distinction, just for clarity. Jump down to point number 69 on page 14 now. Here we go. Homer and Willie purposefully chose to omit reference to the XRP Ledger network and XRP token because doing so would harm the XRP Ledger network and, in turn, harm plaintiff and all XRP Ledger network users. Especially in light of the similarity between the XRP Ledger network and the Ethereum network and the SEC's XRP Not a Security memo, Homer and Willie had no reasonable basis to exclude the XRP Ledger network and XRP from the speech, that's the Ethereum free pass speech, other than the goal to tortiously interfere with plaintiff's valid business expectancy in the network and to benefit their former and now current clients. So as far as them not including XRP, here's the thing. I think Bill Hinman had no business speaking about Ethereum specifically. And it's so weird given that every other SEC official on the planet says, well, we're not going to comment on any specific coin, but then Billy Boy Hinman was trotted out there to speak specifically about Ethereum. That's a little weird. But would you expect, given that there were thousands of coins in existence at the time, would you expect them to go point by point on every single one, naming them? And if the answer is yes, that would be an absurdly long speech at the Yahoo Financial Summit. And if the answer is no, then why should XRP specifically have been cited would be my question there. if the SEC wants to, and I think this is stupid as hell, they can't. I think it's really bad, and I'd fight against this, but they can make these individual speeches about individual coins piecemeal over time. I just think that's horrible. I think that is not appropriately contributing to the market. More precisely, what I'd say is that they shouldn't have commented on Ethereum or any coin. They should just provide guidelines that are very clear, that are actually very clear, having to do with what cryptocurrency is sufficiently decentralized so that it's not a security, and then just let the market go. If they were to do that, you don't need to cite Ethereum. There would be no purpose for the speech. But I don't know. That's just how I think of it. Next, we go to point 78. Here we go. The speech has since been the cornerstone for the near exponential rise in the value of the Ethereum network, and correspondingly been responsible for the plummeting in the value of the XRP ledger network by intentional design of Homer and Willie. So this is another thing where I disagree a bit. And I know it sounds like I pulled up a few things intentionally. Well, that's because I agree with almost everything that's written in here, to be honest with you. And it was actually, again, very refreshing. So this is not some sort of attack. I'm offering just friendly critique, but I definitely appreciate the effort. And we're all disgusted by Willie and Homer, aren't we? Yes. But look, on this point, I disagree. Look, I believe the SEC lawsuit harmed XRP, not so much that the Ethereum free pass speech specifically harmed XRP. What happened with the speech is it favored Ethereum and everything else was more or less neutral, unless you're going to claim that harmed the entire asset class. But I kind of look at it the opposite of that. It's more like it favored one coin and left the rest of them alone. So that's more so the way I look at it. But if you do want to word it as XRP was harmed, okay, fair enough. But don't say, you can't say it's just XRP then. In that case, it's every single cryptocurrency that's not Ethereum got harmed. And if you want to word it like that more precisely, that's fine. But to state that the speech specifically harmed XRP, I don't think that's accurate. I'd say that the SEC lawsuit against Ripple specifically harmed XRP and XRP holders. So just kind of parsing it out a little bit. But that's what my brain thought when I first read it. Moving along here now, page 18. This is my scroll song. Skip-a-doo-bop. Here we go. Yeah, there's page 18. Point number 6 here. Homer and Willie's intentional inference with XRPL network users valid business did I say inference? Yeah, inference with a valid business expectancy. I think, did he mean interference though? He did write inference. Maybe he wrote inference. I did catch a few spelling errors along the way. Like when I read the word rogue, I actually just corrected that. He wrote rouge, R-O-U-G-E, towards the beginning of it. There's just a few little things like that. Anyway. Here we go, 105. Homer and Willie knew that by filing a baseless claim against XRPL network users as they walked out the door of the SEC to work at competitor firms of the XRPL network, the claim would likewise critically impair the XRPL network and cause its destruction. Homer and Willie knew the claim was baseless, as many SEC employees had already concluded in the XRP not a security memo that XRP was likely not a security. Well, again, we don't know that for sure. We just know that they declined to claim that XRP was a security. They did not find that XRP was a security upon submission of that particular memo. That's what we know. But then there was this number 7. So now we go on page 19. Here we go. Number 7. Homer and Willie's tortious interference caused substantial damage. Yeah, there he goes. He did mean interference on the last one, I think. Caused substantial damage to XRPL network users' valid business expectancy. Prior to the public manifestation of Homer and Willie's intentional interference with XRPL network users' valid business expectancy, the network had a value of approximately $70 billion. Upon the announcement based on Homer and Willie's intentional interference, the XRPL network lost approximately $42 billion in value. The XRPL network has also not enjoyed the prior year's increase in value to an extent similar to other blockchain networks due to Homer and Willie's tortious interference. Yeah, so here's the thing. He cited that the network XRPL, so he's talking about market cap, presumably, lost $42 billion in market cap. And he said that the network had a value of $70 billion. I don't know where either of those numbers came from. I pulled up CoinMarketCap, and they have historical snapshots. I pulled up 2 days prior, and XRP price was 55 cents. It was about the same right before the news broke, so it's around that range. which gave XRP a market cap of $25 billion, not 42, not 70. And even if you include Ripple's escrowed XRP, then what do you get? A little more than double that, so a little over 50 billion if you include the escrowed XRP, which our industry seems to not want to do. So I don't know where 42 came from, and I don't know where 70 billion came from. Also, that's not the amount of money that went in. That's just market cap. So in terms of like damages, were there $42 billion in damages? The real answer is no. So like that's, and I try and be precise. I may have failed in the past, but I always try and be precise when I talk about how the market cap lost. The number I'd been citing, because I was going from memory, it was more like, I think $15 billion. XRP went down from 55 cents when it got down to whatever the hell it got down to. It was 16 or 17 cents. I think it was about that. I apologize if I'm mistaken, but about a $15 billion loss is what I'd been saying, but I'd been saying in market cap. And if I ever didn't say that, then that's a failure on my part, because market cap, if it goes down by 15 billion, it doesn't mean anywhere near $15 billion exited the space, because the price gets suppressed as things slide. Just as in good times, price gets bumped up really quickly. So you can have a market cap go up by tens of billions of dollars, nowhere near that much money actually goes in. So in terms of actual damages, I don't know of a great way to calculate that, but it's definitely not 42 billion, it's not 70 billion, and it's not even 15 billion. It'd be a fraction of that in terms of real monetary damages, which isn't to minimize the real losses that people had to endure. I'm not minimizing it. I'm just sharing with you real information here. It is the case that nowhere near that much money was actually lost. It's just because, understand that market cap, it's just what you do is you take the circulating supply times the current market rate. So suddenly, like if the market rate today, what is it today? 70 something cents, I think, 76 cents. I don't recall. Well, if it goes down to 25 cents, in 24 hours, again, you're just taking the current market rate. It has nothing to do with, because you can get down to that price rate very quickly. That's suddenly what the market's willing to bear. It has nothing to do with how much money exited, just to be super duper clear. So I'd have to ask him. I'm sure he's got a good reason for the numbers that he put in there. All I'm saying is I don't know. I'm curious. He may be clarifying that in the future, and I'll be happy to talk about that. But I'm just not sure at this point. And then there's this page 20. Here we go. Class action allegations. Plaintiff seeks class certification on behalf of a class defined as follows: nationwide class, all persons or entities who transacted on the XRPL network and maintained ownership of one or more XRP tokens any time from June 2012 through December 22nd, 2020, the class period. So like I said, from the beginning of time and anywhere up to the lawsuit, that's what's included in this class action. And we're now page 23. So we're getting close to the end here. Here we go. Second cause of action: conspiracy to commit tortious interference with business expectancy by all defendants on behalf of all plaintiffs and class members. Homer and Willie, acting completely outside the scope of their employment with the SEC and in their own personal capacities, agreed to leverage their relationships with their former and now current clients to tortiously interfere with plaintiffs' valid business expectancy in the XRPL network through unlawful purposes by unlawful means. Then there was this. Then we go to page 24. Here we go. Third cause of action: aiding and abetting tortious interference with business expectancy by all defendants. Both Homer and Willie provided substantial assistance and encouragement to each other with the primary intent of critically impairing the XRPL network for the benefit of their former and now current clients. See, that's the thing. Like, it looks like that. That's where I say, like, appearances of impropriety, they're there. Where's the smoking gun on that, though? That's my concern. It looks like it, because you see what they did. Like, we've talked about this ad nauseum on this channel at this point. I suspect that there may be something specifically for that. I mean, maybe they were just going to go after Ripple outside of this anyway, maybe, but it doesn't look right. It doesn't look right. So the thing is to state flatly that, like, where's the smoking gun? Because I'm not aware of one. So I'm just all I'm saying is that might be a little bit tougher to prove. So what are they looking for here? This is the prayer for relief, and I learned this from attorney Jeremy Hogan. This, he said, normally he actually goes to this first when he's looking at new lawsuits. This is where the plaintiff gets to argue like what they want effectively to remedy the situation here. And there isn't a specific dollar figure cited, But so I'm not really clear if they want $42 billion. If you go down this, actually, let me scroll down a little bit further. Here's a civil cover sheet. And again, with me not having a legal background, I don't know exactly how I'm supposed to read into this, but you can see it says dollar demand $42 billion. Does that mean that they're actually demanding $42 billion? I don't know for sure. If yes, that's way too much. That, like, I'm just being for real. Like, there was not that much damage caused, not even nearly. Even if that were the right number in terms of market cap, not nearly that many dollars were actually lost. Which again is not to diminish people that had to endure all of this. We were all there, right? So I'm just being an open, intellectually honest individual here. That's all I'm talking about here. And I don't really feel like I need to read through a whole bunch of this. I guess I could read through one point just to get the gist of it for those of you not looking at the screen. Here you go. This is the prayer for relief. In order declaring that defendants' actions as set forth above constitute tortious interference with class members' business expectancy in the XRPL network as set forth above, and the defendants are liable to plaintiff and the class as described herein for damages arising therefrom. So they do want damages. They want some sort of monetary compensation, and there are other bullet points on your screen right now that kind of indicate pretty much the same thing in different ways and different reasons. And so they're different. There are reasons that there are multiple bullet points with slight overlap. But I don't know. It's kind of like the way I read it. It seems to me like more so just leave it to the court to determine what exactly would be owed. But so that's why I'm not clear on that cover sheet. It said 42 billion is what's demanded, but in here there isn't a specific dollar figure demanded. So I'm not a lawyer. I don't know. I'm just reporting what I know, and when I find out, I'll be happy to share that in a future video. But that's pretty much where we are. So I know this was a long one. You can see now why I wanted to break this off separately. As soon as I saw there was additional content I wanted to cover right before recording this, I was like, okay, well, I can't even deal with this right now. I was like, I just finished reading this thing, making notes. I got to make this video, got to get this out, and then I can talk about the new stuff. So more stuff to cover. I'm going to dig into that as soon as I get this thing uploading, and the very next video will be on that very topic. And I would love to hear your feedback. Are you guys pretty excited about this? Are you thrilled? Are you not happy? Are there negatives that you're seeing? I know that attorney John Deaton has some concerns and critiques about this, just having skimmed what he had to say, so I'm going to learn more about that. It's just tough for me to come up with firm conclusions before hearing both sides of anything, specifically legal related, because if you're like me and you're not a lawyer, I mean, which is most of us really, it's not easy to come to these conclusions because there's so many questions. If you're really just trying to get to the truth of the matter, there's a lot of things that you need to ask and in order to make sure that you sufficiently understand the situation. So that's why I always am happy to share multiple opinions from a ton of lawyers within the XRP community. And there are a lot of attorneys within the XRP community. But I'll wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.